Welcome, welcome. Um, Katie, before we get this thing started off, can you set it up so I can respond to people on the chat as well?
That is
You?
fixed now. Sorry.
No, no worries. All right. Welcome, people. We'll start off at 10 o'clock on the dot. Going to be talking about land sale contracts today. The riskiest of contracts. Hope everybody's having a good Friday so far. Should be a killer training today. We are going to talk about contracts for the sale of land. It's going to be great, and how to memorandize them. We'll start off in about a minute, start at 10 o'clock on the dot, and try and work our way through it in that time. Looks like land sale contracts were not our most popular training that we've done. This is one of the smaller trainings we've had in a while. So make sure if you got questions, you post them up in chat or in the Q&A, and I'll do my best to answer them over time as we go. It's 10 o'clock, so let's get started. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors, and today we're going to be talking about land sale contracts and the Memorandum of Land Sale, specifically as they show in the Oregon Realtors Forms Library. I apologize if my voice is hard to hear. I apologize, and I can go a little louder on this, but let me know. I'm recovering from whatever my 1-year-old gave me. So we're going to start with what is a land sale contract. A land sale contract occurs. It's one of the financing processes that exist for when you have a party purchasing property that can't go through the normal financing procedures. Generally, it ends up looking like a substitute for a mortgage. This is separate from a promissory note and a deed of trust, which is a direct corollary for a mortgage. In essence, this ends up just being a rent to buy or rent to own scheme process. That's the way that these typically work. It essentially is an installment payment process that once the installments are paid, property ownership is transferred. They're also known as installment land contracts, as contracts for the deed, or long-term land contracts. The usual way that lawyers describe them is a land sale contract. The process is pretty straightforward. When the parties enter into the agreement itself, the seller grants the buyer possession rights in the property. They let the buyer move into the property until the monthly payments are done, until they've paid off all the interest and all the monthly payments. Once that's done, there's a final payment. The seller executes a deed of transfer, and the buyer takes what's called fee title ownership in the property, which means the buyer owns it. They actually are the person on the legal deed of record, and they literally own the property. So you sign your land sale contract, you pay money once a month or once every year, depending on how the parties do this sort of thing. And then once it's all paid off, buyer, you own the land. Congratulations. This is different from the normal mortgage process. Excuse me. In this case, the seller still owns the deed and is technically the legal owner of the property on title. The difference is that the buyer has what's called an equitable interest in the property. This is established under ORS 18989. It essentially means the buyer kind of owns it under law, but doesn't actually own the property. And the buyer's equitable interest at any time can get sold off through what's called a writ of execution, where the seller says, excuse me again, Sheriff, the buyer failed to pay on their note. Therefore, I would like you to sell the property, Sheriff, or I would like you to execute the various processes. So you can cut or undo a buyer's ownership in the land through the writ of execution. By way of illustration, this is what a mortgage process usually looks like. This is where you get to see my PowerPoint skills at play. When a mortgage is successful, the bank starts by lending money to the buyer, and then the buyer gives that borrowed money to the seller in exchange for the deed and possession of title. At that point, a mortgage is created. So it sort of looks like this, and then like this, and then the mortgage is created. Great. The buyer then pays off that mortgage over time. Once the buyer has successfully paid off the mortgage ceases to exist. It's usually released in some way, and the buyer owns the property outright. That's a successful mortgage. If a mortgage is unsuccessful, same start process. The bank lends the money. Buyer uses the money to purchase the thing. You got a mortgage established. The buyer pays on this mortgage over time and then makes a failed payment. They stop and they're not able to pay anymore. Oh no, the bank then establishes the foreclosure process. A trustee takes possession of the property, or takes what amounts to legal possession of the property, and begins the actual process for foreclosing, which is an auction sale where anyone can buy the property kind of writ large, and the money from that sale then goes to pay off the debt that is owed to the bank. Anything left over goes to the buyer. Sort of looks like this. You got a foreclosure buyer. Foreclosure buyer pays the bank. Then the foreclosure buyer then takes deed and title to the property, and what's left over goes to the buyer. That's a normal foreclosure in a mortgage. Now, land sale contracts look like this. It's a little bit more simplistic, but this is where the complication is in the simplicity here. So it starts with the seller lending money to the buyer, who then uses that money to give back to the seller and get possession of the property. We kind of pretend that it's lending money, but it's not really. The buyer then pays money periodically, and once they've paid all the money off, deed goes to the buyer, and the buyer owns the property outright. That's a land sale contract that works. It effectively looks like a mortgage where you've got someone that you borrowed money from, and you pay the money back, and now you own the property. Congratulations. A successful land sale contract is going to functionally look identical to a mortgage. As far as the buyer is concerned, they're just paying money to someone until they get the ownership back. The difference is that the buyer has no equity in the property. They don't own any actual interest in the property that accrues value over time. So if the property becomes wildly more valuable over time and the buyer fails to pay on it, they don't get the benefit of the equity accrued. They just live there until they've paid off the full debt. If a land sale contract fails, start point's the same. They pretend to loan money. They pretend to give it back. Possession gets transferred to the buyer. Then the buyer pays on that land sale contract. Let's say the buyer fails to pay at some point. Oh no, possession goes straight back to the seller. The buyer gets no equity. There's no leftover money. Essentially, that little pile of coins on that failed mortgage example, that's the real major difference for most buyers in these transactions, is you don't accrue equity. In the actual contract itself, the Oregon Realtors Form 8.4, this is where we talk about the land sale contract itself. We start with what are called recitals. Recitals are essentially just true statements that exist beforehand. It's kind of like proofs that exist in a legal context, or in a mathematical context. You're basically saying here are things that have to be true for this land sale contract to be established. The seller has to own certain real property. They do own real property in Oregon with a legal description that you'll attach to the land sale contract. The seller agrees that the property is included and all of the included personal property that is in the sales agreement. So this is an attachment to the sales agreement, dated such and such a date, that they agreed to that, and the buyer agrees to purchase it under those terms as well. So basically saying, here's a property, the seller owns it, here's an agreement that the parties agreed to, it has the terms. And then the third recital is that buyer and seller, they should have contacted an attorney and really looked into this thing, had an attorney look at it. If they want to change any of the terms in this land sale contract, have an attorney do it. These are very legally fraught transactions. We'll get a little more into why they're so legally risky for buyers in particular. And because of that legal risk, we would not advise that you just do these because you can. Conventional mortgage is always preferable, in particular because of the SAFE Act, but also because a land sale contract gets really close to a lot of legal concepts that you don't necessarily have a license that allows you to do. So while you can do a land sale contract, we don't advise it. And it's something that should generally be avoided, but they happen. So knowing how they work is a good idea. In the land sale contract, parties can indicate the actual total purchase price of the property, and the buyer can indicate whether they're purchasing it individually or jointly and severally. Joint and several liability is a statement that basically says if anyone messes up on a payment, the other people will pick up the slack. The idea behind that is, if, for example, is the silly example I've got, Two buyers are purchasing property in a land sale contract context. They're paying $1,000 a month. Each one of them should be paying $500 a month. Buyer A, I don't know, gets in a car crash and is in traction and can't sign his checkbook that month. That means buyer B has to pick up the slack, because if buyer B doesn't pay the other $500, if that seller doesn't get $1,000 that month, both parties have defaulted on the transaction. So your options in this case are buyers buying it by themselves, or a bunch of people are buying it together, and all of them will make sure that seller gets their payments no matter who's paying. They just need to make sure it's happening, because failure of one party is failure of all parties. So joint and several liability, it's something that people sometimes do. Just be aware, it just means that you can't assume other parties in good faith will be acting properly. You want to make sure that everything's going clearly. If you're jointly and severally liable with, a bunch of friends of yours who are buying property, make sure they're good for it, because if one of them messes up, they could ruin the whole thing for everyone. The next part of the land sale contract is all of the various terms, the purchase terms. You've got, for example, if there's a down payment, what is the down payment? What's the interest rate? 3, 4, 5, 6, 7, 8%. The reason why we put it that way is if you go under 3%, you start getting really close to where you're violating federal law by having or rather federal tax law, by having an interest rate, a loan that you've created as a seller that is below the minimum applicable federal rate. That essentially means it's a gift to the buyer, which means buyers should be filing gift tax returns, and if they don't, they can get audited. And that would be the seller's fault, essentially, for just not knowing that, and the buyer's fault for not knowing that either. So we limited it on our contract to say you can only do 3 or above, because you're not going to be under the minimum applicable federal rate at 3. And we don't put it over 8%, because once you start getting to 9 and beyond, you start getting closer. And once you get beyond 9%, you're violating Oregon usury law. And we just didn't want to allow people to get to that point where they were on the bitter edge of violating Oregon law. So that's your options: 3, 4, 5, 6, 7, 8%. If you want to do other numbers, half numbers, have an attorney draft the document. It starts getting a little more complicated at that point. All payments will be paid first to any outstanding fees or charges that are due, then to interest, and lastly to the sum of the principal balance. Payments are always going to happen on the first day of the month, and they should be paid within a certain number of days. We'll get to that a little later. It's a 5-day payment period. Payment frequency you can establish monthly, biennially, or annually. And then payment amount is a certain number. You should establish your payment amount. That's kind of what the buyer is working off of. And it should never at any point be less than the sum of interest accrued over any given time. You cannot make a negatively amortizing land sale contract. I mean, you can literally do that, but this contract does not allow you to make a negatively amortizing land sale contract, because that's a problem and it requires a mortgage loan originator, and you just don't want to be an agent involved in a negative loan. It's not a good process. So installments, the payments themselves, will be due on the first day of each month. That's the due date. You have to pay it in lawful money of the United States. So this isn't like that. There's this classic story about a village in England that they borrowed the land or were granted the land by the Queen of England, and every year they have to give her like a hammer, a fine horse, a couple of sheep, and a handful of nails. It's not like that. You have to pay in money. A bag of potatoes does not work. Money is what we're transferring for these contracts. So we're not allowing any kind of funky barter stuff going on. And lastly, who's receiving the payments? Is it the seller? Is it a collection escrow? If it's a collection escrow, figure that stuff out and make sure that you've got it established who's going to be giving their information to that collection escrow. So the seller can be the party receiving the payments. Some parties also want collection to do that, because it puts a third party neutral arbiter in place and simplifies certain lawsuits that can happen. The next part is the maturity date. The maturity date is probably the most important term in the contract. That is the day by which everything should be paid off. Your land sale contract needs to have an end date to it. It can't just be an unlimited, like, oh, I'll just pay till it's done. It needs a date where you say everything will be paid off by this day. This maturity date is generally going to be, if you're going to have any number in the maturity date that is larger than your normal monthly payment or yearly payment, your normal installment payment, you need a mortgage loan originator. The SAFE Act does not allow those kind of balloon mortgages or balloon payments. So you need to actually have a mortgage loan originator involved, and probably not do a land sale contract if you're going to be doing a balloon payment of any kind, because you start getting closer to violating federal law and violating Oregon law, and we don't want to do that. So when you calculate your interest rate or your installments, consider your maturity date very clearly. So if you're saying we want a 10-year loan, this is my example that I've got. Let's say you had a land sale contract for $120,000 over 10 years. That's 120 payments at 4% interest. 120 payments, $120,000 loan. Easy, $1,000 a month, right? No. Because of the 4% interest, it's closer to $1,214 than $1,000 a month. That's very important because you need to be paying off that interest. Otherwise, your mortgage date, like if you said $1,000 a month over 120 payments, at the end of this process, you're going to have $30,000 or $40,000 that are still unpaid, and that means you have a giant balloon payment at the end of the process, and that's a problem. So when you're doing the math on this, do it cautiously. There are processes you can use to kind of figure this out. In general, if you're not super clear on the calculation for the maturity date or the calculation for the interest or any of those things, contact a lender of some sort and have them help you with it. Contact an attorney and have the clients work with that attorney to do this process. You don't want to be involved in a transaction that goes haywire with something like federal law violations or tax law violations. So in general, set the maturity date way out in the future because you can make sure that the installment payments are small enough for that. If the parties are adamant they want like a 3-year maturity date and they want to make it so that it's very clear and clean numbers, then you might have to explain to them how math works, and that's never super fun to do. So just be aware. Maturity date should be when your final payment happens, and it should never be a larger payment than your monthly or your average and installment payment. Prepayment is allowed under the Oregon Realtors land sale contract. If the parties don't want prepayment, they shouldn't be using this contract. We basically said, you know what? It's good for the goose, it's good for the gander, it's good for everyone. If you can make prepayments, it makes things much easier for like the parties to actually figure out the loan process and to actually pay things in when they can. So prepayments, we just said, are allowed without penalty at any given time on the land sale contract, and all remaining sums that are in there, like you'll pay off first the fees and the charges, then you'll pay off interest, and then you'll pay into the primary balance when you make a prepayment. It does not substitute for a regular payment though. So if you are prepaying, it doesn't mean you get next month off. It means you paid extra. You basically paid last month's rent and you keep on paying back from the end of the mortgage rather than from the front. So doesn't substitute for usual payments. That's how prepayment is meant to work. We're jumping in the land sale contract at this point because it's probably a good instance to illustrate what we talk about with this being risky. Default is the next concept we're going to focus on here, which is basically when the buyer messes up. A default happens. There are events that are considered defaults. We start with the classic boilerplate phrase, time is of the essence. What this means in the legal context is all time terms, whenever it says, you have 3 business days, 5 business days, whatever it is, if you don't get that thing done within those days, you don't have this like, well, reasonably, it was, it said 5 business days, but there was a Friday and then I had a weekend. And so I need to give myself 6. Doesn't work that way. Time is of the essence means every timeline is a hard line. It means it's a bright edge, which says if you go beyond this time, you've defaulted. So that's the start point. Time is of the essence. And a default will occur if any of the following happen. If the buyer fails to make a payment within 5 business days after it's due. So if you don't pay by the 5th business day of the month, you are in default on your land sale contract. If it says $1,000 a month and you paid on the 9th, you are in default because you paid late. In each instance where the non-payment of an installment each instance of a non-payment is an independent default. So if I don't pay on time this month and then I don't pay on time next month, you can't just say, the seller doesn't just have to say like you defaulted. They can say you defaulted twice. That's 2 separate instances. You have 2 dings on the record. And the seller needs to send a new notice of default for each individual instance of non-payment. If the buyer is in default under a lien that is attributed to the buyer, that's a problem, and that means the buyer's in trouble. So if the buyer gets the property repaired, for example, or has somebody come in to do work on it, put in granite countertops or whatever it ends up being, and then a workman's lien is applied to the property because they didn't pay their contractor, that's a default. That means that the seller can invoke remedies at that point. So buyer, pay off your liens if you apply them on the property. You're not generally supposed to, but sometimes you get allowed to. And even if you're allowed to, you need to pay off your liens. Buyer's failure to perform on any of the obligations in the land sale contract within 5 business days after getting notice of that problem. So let's say seller says, buyer, you were supposed to do the following thing, fix it. If the buyer does not fix that thing within 5 days, that's a default. That means the seller can invoke their remedies. If the buyer dies, or if for whatever reason the buyer has gone bankrupt or the court appoints a receiver, something like they say, buyer, you're a little unhinged and we don't trust you enough to run the property on your own, so we're appointing some kind of a guardian at court to run this for you, that's a default. The seller can go in and say, well, okay, we have a problem here because I lent money to the buyer for the buyer to own this property, and now some random court appointee is the one running it. That's not what I meant in the first place. So that's a default if you have any of these happen. Death is usually one of those tragic instances where technically the seller gets the property back. Is usually the way death works in a land sale contract. If the buyer makes a fraudulent transfer or conveyance under state or federal law, that's a default. So a buyer, keep your nose clean while you're in a land sale contract. The idea behind that kind of a provision on these fraudulent transfers is essentially if a buyer is involved in a land sale contract and they start doing something sketchy like forging banknotes, that's not a trustworthy buyer. And the seller doesn't want to have their property attached to an untrustworthy party because the seller is assuming that they're getting kind of a good faith payment from that buyer. So seller can back out at those instances where there is fraud. And lastly, if the buyer fails to perform on any of the terms of the contract or condition of the contract, or if there's a default that's attributable to the buyer based on an existing encumbrance, let's say the power company has a line that says you can walk across the property, power company, and fix your power lines whenever you want. The buyer shows up when the power company shows up and they want to kind of walk back onto the property and go and look at the power lines. If the buyer stops them with a shotgun and says, you can't come onto my property, that's a default because the power company has an easement that lets them go onto the property. So at that instance, buyer, you are in default. So there's a handful of things that basically can stop the buyer's ownership rights in the property or allow the seller to pursue remedies. And when we talk about remedies, these are what follow. So if there is a default, the seller can invoke one or many of these, and we'll talk about them individually. The first one is that kind of the first four are the classic default remedies. The seller can demand all the money on this land sale contract become due and payable all at once. If the buyer had a 30-year land sale contract and they're only 2 years in and the buyer messes up, the seller can say, okay, you got to figure it out, get 28 years worth of payments and pay them now because you messed up and I don't trust you. The second option the seller has is do what's called a foreclosure in equity, which basically means they do a foreclosure sale through the county court. That generally looks like on the courthouse steps, somebody stands up there and says, who wants to put money on this? And the parties will put out their various bets and say, I want to put, $50,000, whatever it ends up being, they can put a number down and the highest bidder gets the house. That's a foreclosure at equity. It's a foreclosure sale. That's not typically done in a land sale contract. You don't usually see foreclosures. When it can happen is a situation where the seller doesn't want the property anymore and they're just done with it and they just want to get paid. They want their money. They're already living in retirement somewhere in Florida or something like that. At that point, the buyer can simply or the seller can simply have it foreclosed and then get whatever the benefit of that foreclosure auction sale is. Lastly, the buyer or the seller can request specific performance. They can basically say, buyer, pay it. If the buyer is independently wealthy and they just decided to default on the contract because they don't want to pay it anymore, those are instances where sellers can go to court and say, Your Honor, the buyer should really still keep paying on this. I know they're good for it. And if the court says, yeah, they're good for it, the court can force the buyer to continue paying on the land sale contract or to purchase the whole thing outright. There is also the Section 4, which is that there is the ability to file under the UCC Uniform Commercial Code, basically to repossess personal property. So if in the transaction, the buyer was purchasing in the land sale contract, the house and the washer and the dryer and the fridge and the couch and all those other things, all that personal property is a security interest. It's secured under this land sale contract, which means that the seller can actually repossess it if there is a default. This allows the seller to essentially say, okay, I know I sold you like the fridge and the washer and the dryer and all these things during this land sale contract, but I want them back because it's my house and I don't want a house that's been gutted when I take it back. So they can claim upon the secured property. And then potentially the most important right that the seller has in a land sale contract, and this is one of the ones that for sellers is most often invoked. It's kind of the special sauce that a land sale contract brings to the entire transaction. Is that the seller has the right to end a land sale contract in a process known as strict foreclosure. ORS 93915 provides the timeline. So the buyer has the right to redeem the property, which means basically buy it outright within a certain amount of time. And if they don't redeem, the buyer loses all their rights in the property. It's simply cut. The buyer has no equity. They get nothing back. They are now a trespasser and need to move out of the property. So the timelines on it are if the amount the buyer is owing to the seller is worth 75% or more of the original purchase price, 60 days. That's how long the buyer has to accrue all that money and pay it off. If it's 50 to 75% of the purchase price, 90 days. If it's between 0 and 50, if it's less than 50%, if it's a 0% of the purchase price, then you have no debt that you need to pay off. But if it's less than 50%, you have to give the buyer 120 days to pay it off. Once that 120 days is done, so 4 months, if the buyer has not paid off the amount that they need to pay off in that 4 months, as it accrues, as defaults are happening, the buyer loses all their rights in the property. They're no longer allowed to possess it. They're no longer allowed to be there, which means the seller can just say, you're out, and start a forcible eviction process to essentially move back into the house with full ownership of the equity, as well as all the benefit of having essentially had a tenant for as much time as it was that the seller had that some person on a land sale contract. In this regard, the land sale contract is very seller friendly. It's incredibly buyer unfriendly. Buyers should not be looking to do land sale contracts just because land sale contracts do not accrue any equity for the buyer in the property. If the buyer has a strict foreclosure happen, they have nothing to show for all of their time, for all of their effort, for all of the money that they have put into this property. They have nothing. It is a incredibly risky process for buyers, which is why it is not advised that buyers do a land sale contract in most cases. And it's why in most instances, if you're a buyer's agent, you should not encourage someone to do a land sale contract. Even if you're a seller's agent, it's not highly advised to tell your client you should do a land sale contract, because then they get into the risk of being a mortgage loan originator and the SAFE Act problems. So generally what we would say is, don't tell people to do land sale contracts. If you're a broker, it's not good for anyone in most cases. But what you'll find happens at times, and when the market declines or when the market changes, you might find that land sale contracts become more common in certain areas. It is sort of a way of getting around tough times. In like the 2008 through 2010 timeframe, land sale contracts were much more common because people simply had kind of blasted or blighted credit scores that did not allow them to seek out loans in the traditional way. And when you have a friend of yours who is selling their house and they know you and they trust you, it doesn't matter what your credit score is. The friend wants to lend the house or let you buy their house. That's when a land sale contract sometimes comes into play. If you have your option between a land sale contract or a promissory note and deed of trust, go in the direction of the promissory note and deed of trust, because escrow can fill those out for you. Title can be the one that completes those documents. They have their own version that they will utilize. Almost every title company in Oregon refuses to use land sale contracts. They will not do it. They won't draft them. They don't want to be a part of these land sale contracts because they are legally risky. Now, when escrow doesn't want to do something because it's risky, escrow is risk averse. That means brokers probably shouldn't want to do it either, but they happen. So just be aware. The fifth remedy, or the sixth remedy that the seller has is the ability to appoint a receiver. This is where essentially the seller goes to the court and says, I don't think the buyer's going to take care of my property anymore. I sent them the notice of default. They know they're going to be out in 90 days and they don't have the money to pay it off. And I'm worried the buyer's going to get angry and, I don't know, start smoking in bed or kicking holes in the drywall or something like that. At that point, if the court says, yeah, you're right, this buyer is a flight risk, or they're dangerous and they might cause damage to the property, or they won't maintain it, they'll cause waste on the property. At that point, the court can appoint a third party kind of neutral arbiter called a receiver. That third party then takes possession of the property and takes care of it. While the receiver isn't taking care of the property, they can use, operate, manage, control, and conduct business on the property. So if you've got, I don't know, like an orchard or something like that, while the buyer is in the property, if you're concerned that the buyer is going to let the orchard die, the receiver can hop on the property and they'll be the one that waters the orchard and takes care of the plants and all those other things to ensure that it's at least maintained. If there are various other expenditures for maintenance or improvement, or if there is a need to collect rent or to pay money to build complete construction, the receiver can do that as well. Now, one of the interesting provisions that is generally associated with receivers is when a receiver is on the property, they can borrow money from the seller and simply apply that to the purchase price. So if the buyer started a construction process on a stick barn or something like that, pole barn, and they only got halfway through and then stopped paying on their land sale contract, the seller says, dang it, buyer, you didn't pay on the land sale contract. I'm going to strictly foreclose on you in the next 100 days. And the buyer says, sorry, I'm tough times, can't do it. At that point, if you get a receiver in on the property, the receiver can complete the barn and finish it and say, okay, we're going to finish construction on the barn, because if we don't, the business will be damaged in some way. And the money that we have to borrow to complete this, to hire the contractors right now to finish that barn, we're going to borrow it from seller and just apply that to the amount the buyer has to pay on this contract. So what ends up happening is a buyer's obligation when a receiver is involved can sometimes grow. For a buyer, this is something they should know about. If you're a buyer's agent, let your buyers kind of understand this process, because a buyer might say, well, I only owe $50,000 on this land sale contract. It's a wash. I'll just walk away. You might owe more at the end of the process because contractors have to be paid. And that's something that's allowed under these land sale contracts, in large part because technically the seller still owns the land. And if materialman's lien is applied for work the buyer did, then the seller shouldn't be responsible for things the buyer was trying to get done. So buyers, your obligation under the property can sometimes grow even if you're not using it. That's part of the land sale contract risk, the danger of it. There are also remedies for the seller that are available when the property is being rented to various folks. So just because there is a tenant on the property doesn't mean the buyer can keep gathering the rent from the tenant. The way these contracts begin is it essentially says when buyer takes possession, buyer is going to assign all income from the property to the seller. So the seller technically owns all income coming from the property. At the same time, the seller, in signing this land sale contract, is granting the buyer the right to collect and keep and use all that income until there's a default. So seller technically owns it, and they're just letting the buyer borrow the proceeds from the property until there's a default. Once there's a default, seller can just say, okay, you don't get to borrow it anymore. I'm coming in, I'm collecting the income, or my receiver's collecting the income. So if you have a tenant, you basically on the property that has a land sale contract, the seller can just go to the tenant and simply say, buyer failed on their land sale contract. You're paying me now. I'm your landlord. Not technically a landlord, but like you are going to pay your rent to me directly, not to the buyer. The seller, anything they gather from this sort of a rental income, the seller will apply directly to outstanding fees, charges, and then interest and then principal balance. So the seller doesn't just get to keep it as funny money. They use the income that comes from this property essentially as prepayments on the property itself. So it gets applied to the principal balance every time the seller collects a payment from the buyer. So you don't just get to keep it and have fun with it. It does come off the back end of the purchase and sale or the land sale contract. Once a party is in charge of one party specifically is going to be in charge of paying the property taxes. So you can set that up as the buyer or the seller. Either one is going to be the party that is paying property taxes. If the buyer is paying property taxes, that's fine. Just move along. If the seller is paying property taxes, any amount that the property tax is coming that the seller pays, it gets added to the purchase price, to the principal balance that the buyer has to pay off in the land sale contract. So calculate that into your monthly payments. If, for example, the property has, let's use a simple number, $6,000 in property taxes every year, the buyer's monthly payments should probably be about $500 north of where you thought it was going to be, because you need to pay off the property taxes as well. Failure to pay off these property taxes then clicks it back onto the deal or the purchase price, and that means you might have a situation where you get to your maturity date and you thought you did the math perfectly, and then suddenly there's 10 years of back taxes or the accrual of 10 years of taxes that the seller has been paying, that suddenly the buyer has a balloon payment of $30,000 or $40,000 that they weren't expecting. That's why you want to factor this property tax payment into your maturity date or your monthly payments, unless the buyer is just the one paying it. In most cases, if you have your option to, buyer pays it. Buyer pays property taxes. Now, why do parties not necessarily want to do that? Because generally when you're using a land sale contract, it's because you're dealing with a buyer that is not necessarily financially as stable as they would otherwise be. And in those cases, the seller can sometimes say, I'm not super comfortable with renting my property or giving my property off to someone who is financially unwell. And therefore, I want to make sure that I'm paying the property taxes, because I don't want the county or the state to repossess my property for failure to pay taxes, because I believed that my friend was going to pay it off. So sellers sometimes retain that control and pay off taxes themselves. The easiest way administratively for this to happen is for a buyer to be the one paying the property taxes, but it does mean that you are essentially relinquishing some of the risk and some of the danger of this transaction to that buyer. The buyer, this is the kind of meat and potatoes of land sale contracts. The buyer doesn't own the deed until they've fully paid off the land sale contract. So they are just a person living there who has various rights that are established under a contract until they've paid the whole contract off. And then once they've paid the whole contract off, the seller will promptly deliver a statutory warranty deed that conveys the property free and clear of all liens, encumbrances, and all those other things, except those placed on the property by the buyer or those that were already on the legal title to the property. So if you have existing easements on the property that when you sold it to the buyer, those are still going to be there. Or if the buyer put some liens on the property that had seller approval to do that, then those will be there. Otherwise, the buyer should get what amounts to the same title of ownership that the seller had when the buyer signed the land sale contract. Now, the way this ends up looking in the actual execution phase is the seller signs the deed and hands it to the buyer, and the buyer goes and records that in the county. Now, sometimes the seller will be the one recording the deed. It's an odd situation, but it does happen. In those instances, you need to figure out a way that the buyer is going to be paying for the recording cost. It's usually $93 plus $5 per page or something along those lines. It might have gone up since I was in private practice. That ends up being, it's about $100 to $115 for most properties is what your deed will usually look like. And that price, buyer is paying. So find a way to make sure buyer's paying it. The easiest way to do that is seller just signs the deed, hands it to the buyer and says, buyer, sign this and record it yourself. The buyer signs it and goes immediately to the county courthouse and records it. Buyers, don't delay on recording the deed. Oregon is what's called a race notice state. We'll get to that a little later, but essentially you don't own the property until you have official record in the county record system that says you own it, which means if you have been given a statutory warranty deed that's been signed by the seller, this isn't something where it's a check that if you hold on to it forever, you can still cash it later and without problems with it. Well, I guess that would actually cause problems, that overdraft sort of situation. It's not something you can just peel out and say, now I need to worry about it, so I'm going to go record this deed. You record it immediately because that's when you take literal legal ownership of the property is when the deed is recorded itself. So buyer, once you get this deed, go immediately to your county, like that day, within an hour, and record the deed and get it done because that's when you actually own the property. Because the buyer doesn't own the property until the actual end of the transaction, until they've paid off the whole land sale contract, they are essentially a guest on the land and need to act that way. That means they should not cause waste on the property. That means they shouldn't remove improvements. They shouldn't do these things without seller's approval. So the maintenance provision is usually the classic one that people look at in these situations, which basically says, buyer, you're going to keep all the buildings, the improvements, the external portions of the property, all the outbuildings, all the landscaping, all that stuff, keep it in good condition and repair as though in the same way it was when you took possession of the property. That means if the seller put some real work into the landscaping, buyer, you just inherited a kind of a white elephant gift right now. You have to take care of that yard as well because it is the seller's property technically, legally, until you are fully paid off in your land sale contract. So don't remove things, don't remove the barn, don't remove don't repaint the house, that kind of thing, until you've paid off your land sale contract, unless you get seller approval. You can get written approval from seller that lets you go and do all kinds of stuff. But in general, don't monkey with the property until you have seller approval. If you don't get seller approval, don't monkey with it at all. The buyer, if is able to farm and maintain the property, or will maintain the farm on the property, or the husbandry, the ranching, all that stuff, in the best method known in the industry. So that's what's known as good principles of good husbandry. That essentially means if the buyer has purchased a farm, the buyer shouldn't start just doing some like slash and burn agriculture, where they put in a crop that drains the land all at once, and then suddenly when they stop paying on their land sale contract, they'd be like, oops, I didn't know. How was I supposed to know that almonds would drain your water reserve? My bad. It was fun while it lasted. That doesn't work that way. The buyer is in trouble if that's the case, and that would be a breach of this obligation of maintenance, and the seller could then claim a default and then foreclose on the property, or strictly foreclosed on the property if the buyer has done something counter to this maintenance provision. So buyer, take care of the land because it's technically the seller's land. Same is true for improvements. If the buyer does want to put up a pole barn, or if they want to add a nice porch to the front yard, or make an open concept in the kitchen, they need to get seller's permission first. You shouldn't just do these things without seller's approval. They're literally in the recently last week in Oregon, one of the lawyer listservs among real estate people had a problem that is exactly this situation, where a buyer had a garage that kind of fell apart. They immediately repaired it, and they made some changes without seller's approval. Afterwards, they asked for seller approval, and Seller didn't give it. Now what do you have? You have a problem. You have a serious legal problem at that stage because buyer has just violated the contract in a way that can't be undone. So just be aware, buyer. You're living here essentially as a guest. You are what amounts to a tenant on the property who technically owns the land. You are slightly more than tenant, but somewhat less than an owner. So you aren't supposed to just do whatever you want on the property because you don't own it. There are prohibited activities. Don't do anything illegal or illicit. That kind of goes without saying, but it has to be in the contract too. There is an open question on that is really not answered for what you're supposed to do with regards to illicit activity or illegal activity at a federal level with regards to marijuana. If you have a buyer that wants to purchase property on a land sale contract, they shouldn't be growing marijuana because it's still a federally illegal substance. It's a whatever the schedule something or other substance. So you shouldn't be growing marijuana on a land sale contract property. That is actually legitimately a problem that occurs statewide. More often than not in kind of the southern areas of the state where the marijuana farms are a little more common. If you are on a land sale contract, you are not allowed to do anything that is federally, locally, or state illegal. If you do those things, that's a default. The seller can do strict foreclosure. So if you are growing marijuana in any capacity, recreational, medical, commercial, that is a federal crime technically, which means the seller could foreclose. Even though it's totally legal in your county, even though it's totally legal in your state, it is federally illegal. The same is true on the local level. So for example, and this is the silliest situation that can happen, but if you've got a local place that says no chickens and the seller says, I don't care, I take my chickens with me, and they start raising chickens on the land, the seller can foreclose on this property. They can end the land sale contract because that is in violation of local laws. So buyer, pretend it's a really nice Airbnb that you're super invested in. That's kind of the idea here. Don't kick holes in the wall. Don't do crazy things to the property. Don't do things that you're not supposed to do in this city, in this town. Take care of the land because it's technically the seller's until you're done paying off your land sale contract. There is a gigantic section on insurance. Insurance gets more complicated every year. That's the reason why these provisions get so long. The start point is essentially that the buyer has an obligation to show the seller that they have sufficient insurance to cover replacement of the property. This is fire, casualty, and $1 million per occurrence general liability policy. Now, please note, if you have a property that is on a land sale contract that is worth more than $1 million, you might want to ratchet up that general insurance liability policy. That's something that you would want to have an attorney deal with in most cases, because a land sale contract on a hyper luxury property is something that is probably got more moving parts than you want to be a part of. So be aware. But at present, what we have is replacement value of the property at least for fire and casualty, and a general liability policy of $1 million per occurrence. Seller needs to be an additional insured on the policy. I think that might also say additional interest in one of our later updates, because the insurance companies get all angry about us using the word additional insured. They've created a new term for exactly the same concept, which is additional interest. So in later updates, this will say additional insured or additional interest, dependingly. And buyer needs to provide a copy of that insurance policy to the seller by closing. So before you close the transaction, before closing happens, where the seller pretends to give money to the buyer and the buyer pretends to give it back to the seller in exchange for this land sale contract, this buyer needs to have proved that they have the proper insurance in place. If insurance is modified or canceled, buyer needs to notify the seller, and they need to give very prompt notice if there's any kind of a loss that occurs that's covered by the insurance while buyer is in possession. So if buyer's living in the property and they start smoking in bed and burn the house down, that's a problem. At that point, buyer needs to tell seller quickly. If buyer does not act on this insurance policy, seller is allowed to make a proof of loss and essentially claim on the insurance within 10 business days. If the buyer does not prove that they have insurance by closing, if they don't have the proper insurance in place, fire, casualty, and if applicable, flood insurance, or if their insurance is somehow reduced or canceled or inadequate, the seller has a right to purchase insurance at buyer's expense that covers those things. Now, the seller is oftentimes not going to buy the cheapest insurance policy that covers these things. The seller is able to go to what amounts to the reasonable insurance that is appropriate for covering those fire, casualty, and flood instances. So you may see the buyer's insurance costs go up if the seller is the one purchasing them. That's why the buyer should be purchasing the insurance, because they don't want someone else to be shopping for them. That's kind of the idea behind it. Is the seller should always make sure it's insured, and the buyer wants to lower their cost as much as possible. So buyer, it's in your court. But if the buyer messes up or the buyer doesn't care, seller can get the insurance that covers them to a level of comfort that the seller has on that property. The costs of that seller purchase then get added to the purchase price of the land sale contract. So if the seller is asking for an expensive insurance, it just gets added on to the land sale contract purchase price. So you're noticing over time that there are a fair number of things that can ratchet up the cost of this land sale contract. That's kind of by design. It's the way these contracts typically work. They're protective of sellers, not protective of buyers. Land sale contracts arguably originate as a concept for sellers to encourage buyers to purchase property, but not in the same way that they would like bend over to let the buyer actually like give the buyer a very good terms. They are not buyer friendly contracts. These are seller friendly contracts that the seller can use to kind of sell property to a distressed buyers in some cases. We don't encourage that you seek out distressed buyers to use land sale contracts. They are inherently risky. Please note, application of proceeds. If a loss is payable for whatever reason, the money is paid out to the seller. So let's say the buyer is smoking in bed. Same example as always. I don't actually know if that's a huge problem anymore because it seems like there aren't that many people smoking in Oregon. But let's pretend the buyer is still smoking in bed and they burn the house down. Unfortunate. At that point, the proceeds from this insurance go all to the seller. Seller is the one that gets all the proceeds of that insurance policy. The buyer has the right now to repair the property, to put it back in its original condition. If the buyer completes those repairs, they can send invoices to the seller. If the seller gets those invoices and they're like, yep, you replaced the property to the original quality and I'm happy with it, the seller will then reimburse buyer for the costs of that repair. If the buyer doesn't want to do the repair, the seller keeps the money. In this case, when they keep the money, they apply it first to the fines and fees, then to the purchase price of the contract and all the interest, and anything left over goes to the buyer. So if, for example, house burns down, you had a $100,000 land sale contract that was still in the works. At that stage, seller would keep all the money. They would say, buyer, do you want to pay off you get $150,000 from your fire insurance policy. The seller would say, buyer, if you'd like to repair the property, I'll reimburse you for it. The buyer says, no, I'm good. I don't want to buy that property. So the seller says, okay, then. At that point, what the seller does is they apply all of the proceeds of the insurance to the leftover land sale contract, $100,000, pays off the whole land sale contract. Buyer gets $50,000 in their pocket. And then the seller executes a statutory warranty deed and transfers that smoking husk of a land to the buyer. If there is enough money to purchase the property in this insurance policy, the buyer doesn't get to say, I don't want it. I'd rather have $100,000 in my pocket. They don't get to do that. The buyer instead becomes the owner of the damaged property. Their insurance policy essentially pays for it outright in a prepayment. So that's kind of the way insurance works. You're going to be applying money to the various damages that occur, and the money only goes back to the buyer if the buyer repairs it or fixes it. If the buyer doesn't want to fix it and it doesn't cover the whole land sale contract, so let's say the buyer does something crazy and the porch falls off, and the buyer says, I don't want to fix that, but it's only worth $20,000 and you have $80,000 left on your land sale contract. The seller would get insurance proceeds, $20,000. They would apply $20,000 to the land sale contract. Buyer still owes $60K. And the buyer is now living on the property with no front porch and no ability to get reimbursed if they fix that porch, but they have $20,000 less on their land sale contract. So in the end, everyone's generally happy because the buyer gets their choice of either doing the repair or not doing the repair, and the seller gets the money one way or the other because it's either applied to the land sale contract or it's money that is applied to the repairs that the seller then kind of reimburses the buyer on. Seller has various representations and warranties in his contract. These are the things the seller promises that they're doing. They essentially promise that when the buyer is taking possession, that the seller is able to deliver the property and the various personal stuff or personal property in all of the components they were when the buyer made their offer. Same thing as a purchase and sale agreement. Seller can keep the property insured through closing. So that's for the land sale or the purchase and sale agreement. Even then on the land sale contract, seller is saying, yep, it was insured at least up till closing. Seller represents they have no knowledge of any liens or any of those things on the property unless they've previously disclosed it. So there's no surprise liens or surprise tax assessments that show up. Seller doesn't know of any undisclosed hazardous substances on the property as classified by state or federal law. So if the seller is hiding dynamite on the land, that isn't something that the buyer should just find out while they're like digging around in the garage one day. The seller needs to disclose that stuff. And then the seller has an ongoing obligation to inform buyer when any of this information changes. If the seller remembers in the middle of the night one night, oh no, my dynamite box is underneath the house, the seller should tell the buyer about that. That's an important thing to mention, particularly for hazardous substances, because they can occasionally create either actual casualty losses, or they can cause what amounts to a brownfield site intrusion, where you start creating environmental damage that is then very expensive and costly to fix. And then we also say that seller has no knowledge of discrepancies in the boundaries of the legal description. The property that seller is selling to buyer, they're pretty sure they know where it is. If there is some kind of an intrusion or a conflict with a neighbor, where the neighbor says, actually, I own the next, the eastern 50 feet of this property, that's something that you need to get fixed or disclose around. The seller needs to say, hey, buyer, heads up, the neighbor is trying to claim against the eastern 50 feet of the property. You can disclose those things, but if you don't, the seller is warranting outright, hey, heads up, I think I own everything within the legal description of the property that I'm selling you. There are no other contracts, so this is the whole deal between the parties. If they have an oral agreement, if the buyer and seller say, let's do a land sale contract, but if the Patriots win the Super Bowl again, then I'll take 50 grand off your contract, and they do that orally, but they don't put it in writing, that's not in the contract. It is only the written things in this contract that make up this contract. All of your oral agreements beforehand don't count. And then lastly, seller has fully disclosed all of the material information that seller has about the property that seller knows. So if seller is aware that, for example, once a year there's a catastrophic flood that, destroys part of the house, seller should inform the buyer before the buyer purchases. That's something that needs to be disclosed. Seller will also covenant that they have consent from all of the various parties that they need to get consent from for the previous liens on the property. So, for example, this is something that can happen. Seller has a mortgage on the property, and they say, hey, buyer, heads up, I have a mortgage on the property. The mortgage has a due on sale clause, which means as soon as I sign this land sale contract or the purchase and sale agreement, in theory, I owe all the money that's left on my mortgage. In the same way that you can call the loan on this land sale contract, the bank can call your mortgage. Due on sale clauses are in pretty much every mortgage. So let's say you have that seller with a mortgage with a due on sale clause, but the seller's doesn't have enough money to pay off the mortgage outright, and they were planning to use the money they get from the buyer in this land sale contract to pay on the mortgage. The seller can talk with that bank and say, hey, bank, I'm going to sell this house on a land sale contract to this buyer, and the buyer's going to pay me, and then I'm going to pay you if you're okay with it. And if the bank says, yeah, that's fine, then you have approval from that bank that and essentially you'd want an affidavit that says we're not going to invoke our due on sale clause, and then the seller would have obtained all the consents they needed to sell this property. If the seller doesn't have that consent, they should not be selling this property even under a land sale contract, because the bank will foreclose on the property while you're in the middle of your land sale contract, and that's a problem. Same is true as if the seller is saying there's no default, failure, or condition under a prior lien that could ripen into a default. If seller is derelict on their property taxes, for example, that's a problem, because the county can foreclose on the property after the lien is applied and is there for long enough. And lastly, the seller says they're going to make payments on any of the prior liens that when they come due, and they'll obey and observe all the terms of those liens. So if the seller has to pay money, property taxes, for example, they will. That's the idea of that provision. If the seller does fail to pay on an obligation, this is one of those places where there is a little give and take. The buyer does get a right back. The seller, for example, fails to pay on an obligation. Let's say it's the mortgage payments. The seller fails to keep paying their bank the mortgage payments, and for whatever reason, the buyer finds out about it and knows about it. The buyer is allowed to pay those liens off, to say, okay, I will pay the mortgage payment then. However, anything I pay on the mortgage, we're going to credit towards my next installment payment. That means if I'm supposed to pay $1,000 a month and the mortgage is $1,100 a month, if I pay your mortgage this month, I am paying the whole installment and $100 prepayment. So the buyer can essentially forward money into the land sale contract by paying off obligations if the seller fails to pay on them. This is an irregularity. The provision is there because it happens, but it's something that shouldn't happen often. And then the last piece here is that the buyer will not cause or suffer any act or failure to act that is, if attributed to seller, will cause a default under a provision of a prior lien. So if the seller's mess up causes a foreclosure, that's a problem. The buyer's mess up causes a foreclosure, that's a problem, and the buyer needs to make sure that doesn't happen. If, for example, that there's a power line easement and the buyer says you can't come onto my property and stops the power line guys at the fence line with a shotgun, at that point, The power company would probably claim something in a court of law and get a judicial order, a judge's lien, and over time they might have a right to actually foreclose on the property. That is something a buyer is not supposed to do. So this provision right here, this is how we stop buyers from stopping the power company at the fence with a shotgun. Because if the buyer does that, they're in trouble because they might be causing defaults under other liens that would be attributed to the seller. Now we're getting close. The last section on the land sale contract, and then we'll talk shortly about the memorandum of land sale. All personal property, when you're transferring the fridge, the couch, the washer, the dryer, all those things in these purchase transactions, they are secured interests. That means that the seller can at any time file a financing statement, and essentially that would perfect their interest. It means that they can repossess it when it's perfected. If there is a foreclosure event of any kind, if there's a strict foreclosure or a judicial foreclosure, all those things, the seller can say, buyer, I'm coming after all my personal property too. And if that is successful and there's a default under the terms of the land sale contract, buyer has 3 days after receiving this written demand from the seller to make that personal property available to the seller. That means in some cases putting it in boxes in the garage so the seller can pick it up. It might mean putting it on the curb of in the front of the house so the seller can pick it up. But the seller is able to retake those objects and basically get them out of the property now before there's a problem where you're 30 days into your foreclosure and the buyer gets angry and decides to kick a hole in the fridge. That is why the seller can essentially repossess all of the transferred personal property as a part of this land sale contract. So it is by the contract terms secured as an interest. But if the seller is really concerned about it, file a UCC financing statement, and the buyer will assist in that filing statement or financing statement. Memorandum of land sale contract. You'll note up at the top it went 8.4, now it's 8.5. We're on the memorandum of land sale contract and we're almost done here. Memorandum of land sale contract is just because Oregon is what's called a race notice state. This is under ORS 93.640. This essentially means that you don't gain title to your title doesn't manifest. It doesn't become super effective. It doesn't actually become valid until you have title that is recorded in good faith before other claims against the property. This exists for what's called the wild deed situation, where you have a seller who sells the property to buyer A and then a month later sells it to buyer B. If buyer A and buyer B have both purchased the property outright, now they both have claims against the seller because there's some kind of a fraud going on. But if you sold the property to buyer A and buyer B bought it a month later, but buyer A just never got around to recording the deed, when buyer A in good faith purchases the property and records the deed not knowing about buyer A, buyer B owns it, even though they bought the land second. That's how Oregon works. It's essentially the first to file is going to be the one in good faith is the one that owns the land. So that first to file process means you want to make sure that you have an official filing for any interest you have in the property. The memorandum of land sale contract is how we do that for a land sale contract. We essentially lock in the buyer's ownership rights of their equitable interest in the land by recording either the land sale contract in its entirety or a memorandum of land sale contract. Because recording a document is about $100 plus $5 per page. When you've got a 20 some odd page document that you have to record, it gets expensive. So rather than doing that, let's do a memorandum of land sale contract. It's 2 pages long usually. That means it's only about $100. It saves some money, it saves some time. The memorandum of land sale contract gives anyone who's curious about that property notice. They can go to the county record system and look through the records and see who owns the property. They'll see the deed that belongs to seller, but they'll also see a memorandum of land sale contract that says, heads up, seller has a land sale contract with buyer that is maturing on the such and such date, which means buyer technically has an equitable interest in the property. So if you want to buy this land, you need to talk with both buyer and seller, not just with seller. And so it gives notice. It lets people know, curious buyers who want to purchase land will then know that there is someone else with an interest on the property, and it's done by recording this memorandum of land sale. It starts off in a pretty traditional way for recorded documents, which is essentially who do you give the document back to after you recorded, who's the buyer, who's the seller. There's the little space that you stick the sticker on when you record it. And then we also have who do the tax statements go to, buyer or seller. You can check that box and you'll say it goes to buyer or it'll go to seller. This memorandum is recorded in the county's deed system and record system. It's not a state filing, it is a county level filing. And it will be filed in the county where the property is located, not where the buyer or seller personally live. It is literally where the property is located that you're filing this thing. The actual memorandum of land sale contract, this is almost literally all that it has. It says, hey, there was a land sale contract that was signed and dated on right in the date of land sale contract between the buyer and seller for a total consideration of a set amount of money. I see a question in chat. Under what ORS is the land sale contract? The land sale contract is not actually established under the ORS anywhere. It is a common law creation. Which basically means it's just something that British lawyers and Whigs used to do way back when. It is referenced in the title provision in the ORS sections in 93 that talk about transfer of deed, where it says if you're transferring deed, trust deed, or land sale contract, it does reference it, but at no time is a land sale contract actually given like legal standbys or legal form in Oregon law. So it is a creation of lawyers expressly, and that's kind of how it exists. This legislature has never established it officially. But it also says essentially you have a land sale contract that had a consideration of whatever your purchase price was, where a seller agreed to buy an interest in a property that is at the blank address located in a county with the following attached legal description property. All amounts due under this land sale contract will be paid by the maturity date. Essentially, the person looking at the property needs to get notice that says, hey, this person will officially own the land by the maturity date. By this day, you're just talking to buyer, unless something goes critically wrong. That's what the maturity date statement in this is essentially for, to tell the parties that are interested, heads up, if you don't want to negotiate with two parties simultaneously and get one of those kind of weird transactions going, wait until the maturity date, and then the buyer owns it outright. It also has the boilerplate language that the state of Oregon requires on transfers of title and fee, which basically says consult a lawyer if you're concerned about the law stuff, consult your county if you're concerned about the county zoning stuff and planning stuff. And then the very end of the land sale contract has essentially a space for the buyer to sign, the seller to sign, and then notary blocks for the parties to notarize the document that says, this is my transaction that I promise officially in the notary's book that I am the person I say I am. They've seen my identity. And that's the whole memorandum land sale contract. And that takes us to the end. I see a question that says, if the owner will carry the note, then what is the ORS? So the question is, if an owner carries the note, then is there an Oregon statute for that? If the owner is carrying the note, as in like a promissory note, that's its own separate part of the statute, that they would use this promissory note and trust deed. I believe it's ORS 93 that has stuff about promissory notes. Don't quote me on that. This training is only really designed around the land sale contract. For promissory notes, our plan was to do it last week, but scheduling got kind of wonky. So it should happen, I think in mid-June is when we're going to, or potentially early July is when we do a training that's going to be on promissory notes and trust deeds. At that point, that's when we'll get much more in depth on what the process is. If the owner is carrying the note, they have the promissory note that's going on, and it's not on a land sale, which is just installment payments over time. And then once the last installment happens, ownership occurs. Are there other questions? If not, I've taken you to 10:59, which is right about the time limit we were looking for. I hope everybody has a good weekend and enjoy the weather and have a good Memorial Day. And if you've got questions, feel free to post them in chat. If not, feel free to send them to legal@OregonRealtors.org or forms@OregonRealtors.org, and we can do our best to address those questions that you do have. I'll stay on for a couple more minutes, just see if any other questions pop through. Otherwise, everybody have a good day.